We are observing a continuing trend in post-M&A disputes, whereby the buyer increasingly bases claims for damages not on the breach of warranties, but on the seller's intent failure to disclose information which cannot be identified through due diligence. In this respect, the seller's obligation under case law to inform the buyer without being asked of any circumstances that could frustrate the purpose of the contract and are therefore of essential importance for the buyer's decision to purchase plays an important role. If there are indications of such misconduct following a transaction, it may be worthwhile for the buyer to investigate. This is because claims arising from corpora in contrahendo due to fraudulent misrepresentation are not subject to the restrictions in the agreed liability regime of the SPA. Under certain circumstances, an excessive purchase price may also be claimed as damage.
It is customary to agree in sale and purchase agreements for companies to use arbitration clauses for solving legal disputes. It is also customary to include clauses according to which certain disputes between the parties are to be decided by an expert, in particular for the determination of the purchase price resulting from closing accounts or for the calculation of an earn-out, and not by the arbitrators under the arbitration clause. Whereas the distinction is, in principle, clear, the distinction is in practice often not that clear, as the determination of amounts by an expert frequently requires decisions on legal questions. In such cases, the basic approach will still be the competence of the expert, as he is the person who has to decide on the calculation of the amounts in dispute under the SPA. In case the legal questions are simple or within the normal scope of the work of a chartered accountant, there is no reason to assume that the parties did not have the intention of also submitting these questions to the expert. However, if there are complicated questions of law, the answer is less simple. The expert may refuse to decide on such questions. If the expert decides, one of the parties might try to argue that this was outside the scope of the competences attributed to the expert, requiring lengthy proceedings on the respective competences. When drafting SPAs, it is therefore important to consider these competence issues and to try to find stipulations covering these situations.